Before someone is put on trial in Alabama, there's a step called the grand jury. It's a group of citizens who hear evidence from the prosecution, not the defense, and decide if there's enough to move forward. If they believe there's probable cause, they issue an indictment, a formal accusation of a specific crime. The grand jury doesn't decide guilt or innocence. It decides whether a person can be officially charged and face trial. That indictment defines the boundaries of what someone can legally be tried for, and in Jason Green's case, those boundaries were crossed. An indictment is the formal accusation. It's what tells the person, this is the exact crime you're being charged with. In Alabama, the indictment is the blueprint for the whole trial. Everything, evidence, defense strategy, jury instructions, it all depends on the charge listed in the indictment. The Constitution guarantees that you have the right to know what you're accused of and to defend yourself against that specific charge. But in Jason Green's case, he was indicted for intentional murder and convicted of a completely different legal theory, causing a suicide through reckless conduct. That charge, never in the indictment. That's not just unfair, it's unconstitutional. In a criminal trial, a lesser-included offense is a charge that's naturally built into the greater one. For example, if someone's charged with intentional murder, the jury might also be allowed to consider manslaughter, because you can't commit murder without also causing a death. But there's a legal limit. The lesser offense must be based on the same core facts and theory as the indictment. In Jason Green's case, he was charged with pulling the trigger, but he was convicted of causing the victim to shoot herself through emotional recklessness. That's not a lesser offense. It's a whole different accusation. And that should never happen without a new indictment, a new defense, and a fair trial.